At Luke's suggestion, which I thought was a great idea, I'd like to suggest that we amend our agenda. So moving item 5 to the first spot and item 4 to the second spot. This is because Mr. Kennedy is with us. So Mr. Kennedy doesn't have to sit through our entire meeting. Luke thought it would be a good idea, and I agree, if we could move those two up so that he can give us the information he needs to share, and we can discuss it with him if we have any questions, and then move on to the other items that he's not required to be a part of the discussion. Everybody okay with that?
Sure.
All right, Luke, do I have to do anything since technically there was an agenda posted?
Yeah, I suppose we should do it by motion.
Okay, I'll make a motion then to amend the agenda to move items 5 and 4 into the first and second spot to be considered. Is that adequate?
Yeah,
would
we
you-
would just need a second and then we can vote
Okay.
by acclamation.
Okay,
So Mr. Rock seconded. All in favor?
Aye.
Any opposed? Okay, so motion passes.
Thank you. And that was, I apologize to Dennis. I had emailed him. I said, I'm sorry that I hadn't thought of it first. So thank you, Luke, for that suggestion.
Luke charged me $20 to do it.
I wasn't gonna go there, but I
That's
thought
not
maybe.
true for the record. That's not
For the
true.
record, that's not true.
That would be an
Going
ethics
on his
violation.
W-2 at the end of the year.
Not funny.
Not funny. All right. So with that dispensed of, so the first item then for our consideration and discussion is the fees for uncertified assessment search requests. Dennis, do you want to give us some background? I know I had been approached in April by a title company, and I ended up forwarding it to you.
Yeah, thanks, Barbara. I had circulated a memo with some background on that. Basically, what title companies do is they'll first check with the county to see what special assessments are on a property. That's anything that's either in the process of being sold or contemplated for sale. And they'll also contact the local political subdivision to see if there's any uncertified special assessments. Special assessments are certified to the county by all political subdivisions, usually in the first 10 days of September. So anything that occurs after that, that's potentially going to be levied on a property in the subsequent year would be maintained by the city or village or township. Our uncertified special assessments are usually in the realm of things that are for nuisance abatement, grass cutting, those types of citations that are only filed then once a year. We don't really have a lot of them, but we get a lot of requests. And the title companies will either call, send an email, fax, which nobody does anymore. But we'll get anywhere, like I said in the memo, from 5 to 15. It could be 25 in a week. And the logistics of the whole COVID situation caused some difficulties because in a lot of cases, I would be the only one in the office and the emails go to somebody else's computer or the faxes go to somebody else's fax machine. And we're kind of trying to rush and scramble around to get these things back. And the title companies, I know from the county, already charge in their closing statement a fee for a special assessment search. So the person that is doing business with the title company in their final closing will actually pay that fee. What I'm proposing is that we assess a small charge for the search to get this information for the title companies and respond. If you go on the basis of anywhere from 5 to 15 a week that we get currently, and you say, for example, charge $15, then that could bring anywhere up to $3,500 to $10,000 a year in revenue, which, you know, it's not a monumental amount of money, but it could pay for something. And what I'd really like to do, based on the success we had with the special pickup website design, is to really refer all these, which I can do through the real estate Agents Association and Title Agency Association to just have them file these requests online. I've already talked to our web developer. We can put up a page similar to the special pickups. Somebody goes in and enters their data, puts their credit card information, pays it, it'll come right to me. We can get that response back and we can guarantee 24 to 48 hour response time. We don't deal with all the phone calls and the faxes and the emails. And they're very persistent and aggressive, obviously, because they want to get the sales closed. So this will be something we can kind of keep the pesty request down to a minimum, manage it better, and make a little bit of money for the city. I don't sense any opposition from any title company. They're just going to pass that small fee on if it's not already included in their special assessment fee to the buyer or seller, who's ever responsible for the closing. So with that, I open it up to questions if anybody has any.
I have one. Well, first of all, it sounds like it makes perfect sense. It's a lot of legwork on the part of our employees to provide all of this information. We certainly understand that they need it, but it's a much more efficient way of doing it. 21st century. Do other communities do something similar? Do you know?
It's not a universal charge, but you know, it's probably in the area of 30 to 40%.
Okay. I mean, it makes sense that if you're having to do all of this additional work, that there should be some type of charge associated with that.
Yeah, and it's not, I don't want to give you the impression that the work is overwhelming. It's not.
No, but it is
that
additional steps that you're having to do. And like you said, if you get lots of them, somebody's got to be doing it. So.
Yeah, and they're interested in getting immediate results. So, you know, we'll get a fax and then we'll get an email to tell us that they sent a fax. Then we'll get a phone call to tell us that we got an email.
Email and a fax.
And they want to get that done right away. So if they're that aggressive, I think they won't be that opposed to a small fee. That was my thought.
What does everybody else think? I think it makes sense.
Yeah, I think anytime we can save you, unnecessary hassles and enable you to do more of the important work, it's a great idea.
I think it's a service that has value and there is a cost to providing it.
Right.
And the fee simply defrays what it costs us to provide the service.
Yeah. And I like that there's a convenience factor involved, that it'll negate a lot of telephoning or emailing or faxing, or, none of it can really fall through the cracks. They are responsible for putting in that application and paying for it. And there's one repository that it all gets facilitated through. John, what do you think?
Success with the pickups with that
Right.
portal, really good success.
I agree.
Justin?
All for it.
Okay. So Luke, how would we move forward with instituting this? Is this something that can be done administratively, or is this something that requires
I would
something more?
suggest adding it as a fee in the codified ordinances.
Okay. That's what I thought.
So why don't I put together an ordinance and have it,
Okay.
for your next meeting?
Wonderful. And I think Dennis, explained it pretty well to everybody in the email, but certainly you and he can craft something for council's consideration. Thank you very much. Thank you, Dennis.
Okay, thank you.
Barbara,
Anybody else have a question, or?
Thank you, Dennis.
Barbara, are you, is Luke drafting this to come back to committee, or is he just basically, are we going to draft it and present it to council as a whole? Are you?
That's an excellent question. I mean, unless anybody has any concerns, it seems like everybody thinks it makes sense. I think that we could have them do that and send it to council, or would you prefer to look at it one more time before we do that?
No, I have no preference. I mean, I think it seems like a simple enough idea
It
that
is.
we're really just creating a schedule of fees
It-
and that could go
Yeah.
right to council.
Right,
so
it-
we-
It should be fairly simple, and my recommendation would be that it go on council's agenda, and then if council has an issue with it, they can refer it back to committee
Exactly.
from the council floor.
Pretty straightforward, but that sounds like it makes
It,
sense.
it should be the case that if there's any issue with it, it's a simple enough, concept that it could be amended on the floor.
Okay.
So I think we should get it on the council's agenda.
All right.
Famous last words, Luke.
Yeah, I'm knocking on wood.
Thank you. All right, thank you very much. Let's see, next item. The review of mortgage rental and utility assistance programs. These were 3 ordinances that the mayor had brought to council for their consideration. With COVID impacting the economy like it is, certainly there are folks who are finding it challenging to meet obligations. It was suggested that there would possibly be funds that the city would have related to the COVID funding that we are getting, that we might be able to have a program or programs in place where grants could be given to folks. They would apply, they would, everything would be considered, and it would, folks would be chosen that they could have that kind of assistance to meet rent or mortgage or utilities. Dennis, if I could ask you to, I know you've spoken to this before, but if you could just clarify, I know we had emailed about how that would be, how those funds would come to be that could be used for that purpose.
Okay, there's just a couple of distinctions. There's COVID money in general, and we get that from a variety of sources. The major one is the CARES Act money that comes from the federal government. We've received a number of other revenue, small postings from federal health and human services. We had a workers' comp rebate of a little over $200,000. We will get another workers' comp rebate of $155,000 and some change that I'm hoping is going to post tomorrow. And we just got a notice, I don't know if everybody read the recent update from the governor, that the Bureau of Workers' Comp has decided to issue $5 or $6 billion more in refunds. So we will get another distribution, they're telling me prior to the end of the year, of about $577,000. So when we talk about the CARES Act money, that is the money that went into the special fund that we set up. It's Fund 297. That is the money that Luke and I reviewed all the guidance from the federal government and from the Office of Budget Management and the state auditor on what we could spend it on. So ultimately, when at the end of September, the guidance directed us, and Luke provided a legal opinion, that we could use that money to support actual acquisition of materials and supplies for COVID-related issues. And we can also offset some of our salary and benefit expense for our safety forces. That's the day-to-day operational folks, not the administrative help, not the chiefs. So that's what we've been doing in April. At the last council meeting, I came back and asked that money be appropriated in that fund for the total amount that we received. That's a little bit over $1.1 million. And as of today, tomorrow's going to be the end of the month, I have closed out expenses in that for a little bit over $1 million. There's another $80,000 of monies that are encumbered, but I want to use all 98% of that money will be used up by tomorrow. The other 2% will be used up in November. I think where the confusion comes in is that money is already going to be set aside for those purposes. But once you transfer that expense, think of it, if you spent $1,000 in the general fund and you started out with a $2,000 balance, you would end up with $1,000 left in your fund balance, and you would have used up $1,000 of appropriation. If I take that $1,000 and move it to this COVID fund, 297, that restores that $1,000 of appropriation in the general fund, and it also restores the fund balance. So the money in essence goes to another cash account to take that money and restores that money in the general fund. So the money that the $1 million that was expended that would normally go against the general fund is now going to be absorbed by this COVID fund, 297. So that money then, that $1 million, just for the example purposes, is back in the general fund, and it's available for use for whatever subject either the mayor or the council wants to use. You also have the ability to reduce those appropriations by that $1 million, so you're not using it for anything. The fund balance will still be there. It'll be there to start out next year. But when we talked about these programs, I said, we're going to use all the money for COVID expenses and for payroll, but the displacement in the general fund would allow you to fund these programs if you so desired.
Okay.
I don't know.
And that, I appreciate you making those distinctions and that clarification. Have the chiefs, specifically Chief Perko, I'm sure he's spoken to the mayor or safety director, with everything spiking off the charts and we don't have any idea how much worse this is going to get or for how long. What are his needs with regard to PPE and having an adequate or more than adequate stock? Because I know he's expressed concerns in the past and was able to have enough on board. But has he said anything about what his plans are with regard to needing to make additional purchases in that regard? Mayor?
I believe he has made the purchases that he was looking to make at the time that we brought them to council.
Okay.
I don't think we are looking to do another PPE purchase of that kind
Okay.
imminently, and not for use in this calendar year.
Okay.
And for CARES Act, they're looking for, they don't really want us to stockpile for years.
Mhm.
They want us to.
Right.
Right.
I just want to make sure that his needs are met because obviously they are out there on the front line of this and I want to make sure they have everything that they need.
Yeah, I did, Barbara, talk to him earlier this week. I gave him the okay to purchase. He made one additional purchase for some PPE, probably in the neighborhood of $5,000, but I believe he said that will carry him
Good.
inventory wise into the beginning of next year.
Okay. I've had calls from a few residents who had heard about the potential of programs where they could be considered for this kind of assistance. I think it's a great idea if we were able to do it. This is something nobody could have anticipated, and it's really rough and certainly more difficult for some folks than others. So I'd like to open it up. Who has some thoughts on this? Mrs. Weiss?
I just have a suggestion. We have, about 8 weeks left in the year.
Mhm.
Maybe just sit tight and kind of see how the end of the year goes with cash.
Mhm.
And then, revisit it in January. It doesn't even have to, necessarily wait for the budget in March because it's not that much. But, just kind of see where we end up in December.
We have a
31st.
little cushion.
Yeah, I mean, and we still don't know 100% where Rita's holding. I mean, there's some, questions still up in the air. Maybe just sit tight for a few more weeks and then reevaluate.
And
Thoughts, anyone
additionally,
else?
sorry to butt in,
No,
but the state of Ohio just announced a program for rent, mortgage, and water or sewer utility bills, which they would cover the rent, mortgage, or utility bills. Which,
Oh,
open
wonderful.
on November 2nd and is open through the end of the year. So I'll forward that link to all of the council people. So if
Thank
anyone
you.
asks you about it, you'll have that information.
That I much appreciated. Okay, good. Anyone else have some
I'll
thoughts?
agree
Sue?
with,
I have something.
I'm sorry, about holding off until we see what we're doing with cash flow, but does this have to be encumbered by the end of the year?
Dennis?
Well, if it were CARES Act money, it would be, but I think what Dennis was saying was we're using all the CARES Act funding on the supplies that we've already purchased and on the payroll. And so this would be a general fund
Okay,
allocation.
got it.
I think it's fair to say that, if I may, that because we've worked that out that way so that we aren't subject to that deadline to encumber that money, that we are in a position where we can wait and see. We can see how the state program works out. We can see how, with the Bureau of Workers' Compensation disbursement that's going to all businesses, how that affects the economy. We're in a position where we can wait and see. I mean, when Brendan and Susan prepared at my request these programs, there were a lot of variables that are different now. And the thing is there may very well still be a need that surfaces for these programs, but I think we can take a wait and see approach at this point.
No, I think they're a tremendous idea. I was really pleased to see how well thought out it was, and I mean, they did all of the pieces. So kudos to everybody involved in having developed those. But I think it would be a wonderful thing if we are able to, if we need to, if, you know, I think it's wonderful if the state can do it. But if the need arises and we're able to, I would love to be able to provide that. Anybody else? Justin? Phil?
I think that's a thoughtful approach.
Likewise.
Okay. All right.
Thank
Well,
you.
Dennis, anybody else have anything for Mr. Kennedy? Hearing nothing. Thank you very much, sir.
Good night, everybody.
Have a great evening.
See you tomorrow, Luke.
Thank you very much. Okay, so we are moving on to our favorite, review of codified ordinance section 1280.10, rental registration. I know that Mr. McConville had sent everyone the most recent red line version of it. And we had discussed that at our last meeting. He had provided that. Where are we on this? Thoughts?
Well, I can give a review on a few
That would be great.
topics. And
Okay.
So the last time we met, I think we were having a discussion about a particular hypothetical that Mr. Rock had raised, and John, step in if I'm, kind of getting this wrong, but I believe it was a scenario where you had domestic partners living together, and perhaps some of their family members also living in a home that was owned by one of them, where the homeowner was in the military and called away for service, and so he was no longer going to be living there. And the question I think that was being raised was whether that was going to trigger a rental registration requirement, because the folks who were living with the owner of the home were now going to be living in a home that the owner wasn't in anymore. And I, as I read through the ordinance, my impression is that the combination of the domestic partner language on the one hand, which indicates that domestic partners are not obligated to obtain a rental registration, and provides a definition of domestic partners. That on the one hand, combined with the functional family equivalent definition, which allows folks to come into BZA and present their case that they're not merely more than 3 unrelated persons and who are just roommates, they're more of a functional family and meet the criteria under that definition. The combination of those factors really provides protection for people that are in the situation you're talking about. Because I think if there was testimony of any kind, whether it's from the partner or from the owner, that, hey, the only reason I'm not there is I've been called away for military service or for business or for whatever the circumstances are, it's temporary, I'm going to be moving back. That the reasonable interpretation by the building department would be that that's a domestic partner situation that's not subject to rental registration. And if for whatever reason the building department disagreed with that, for particular facts and circumstances, the issue could be appealed to the BZA and the BZA could take a look at it. So my sense of the changes that we made to the ordinance is that they're really providing substantive additional protections for, domestic partners, for non-traditional family units, and that we probably should be careful about not trying to specifically address every hypothetical, because we can end up shooting ourselves in the foot that way if we've addressed one situation but not another, and we set up the argument that, well, since you're saying yes to one and you're not including another, that must mean that they need to go get a rental registration permit. My sense is that the changes that we've made really do provide substantive protections. So I guess I would open that up then for comment.
No, I agree. And I really appreciate you taking a look at this and adding the word domestic partnership to part 1 under whether the permit's required, and then the whole language here as part 4. I think this is very comprehensive. This is very good. I understand you don't want to get too specific with people, but I think as it is 2020 and most people I know in my age group live with their significant other before getting married. So it applies to most people, I would say. I just wanted to make sure that those people are protected. Additionally, the fact that we're going to call domestic partners, whether they're same sex or opposite sex, there's certainly doubt in the future whether a same sex marriage would last if the law would allow that to stay. And so I just want to make sure, same-sex couples afford the same privilege and protection in the city as opposite-sex couples in the event that the Marriage Act is struck down in the future. So I'm glad this is in here. This makes me feel good, and I'm okay with that. I'm good with it.
Now, Mr. Rock, I'm really glad that you had raised that. Especially, we are definitely a city, a community that is inclusive. We've proven that with a number of ordinances and our recognition of Pride Month, and it's, all of our neighbors deserve the same opportunities and protections with regard to anything. So especially with something as essential as housing. So, and to be secure in that. So I appreciate that.
Thank you.
As long as we're being inclusive on same sex and opposite sex, should there be any notation here about people who are non-binary or don't identify either way?
Is there language, Luke, that can provide that distinction?
Well, I think this, because they're saying same sex or opposite sex.
It's going to cover most, but as long as we're trying to cover everybody.
Right. Certainly in 2020, it's almost boilerplate in a lot of things that you see. So I don't know. What do you think, Mr. McConville?
Sorry, Luke, I was trying to unmute myself and I ended up muting you.
Very clever.
Would it be?
Can you share why gender or why sex was included in that section?
Yeah, we lifted this from the city of Cleveland. I can't remember which policy it was. this was suggested language, so we were parroting their language. You know, we could just eliminate the whole clause of the same sex or opposite sex, and then it would just read individuals. I think that
That's-
might
I think
take
that's
care of
fine,
the
because as
issue.
long as the criteria is met in
Right.
1%, it doesn't
Yeah.
matter what sex they are.
Mhm.
Right,
Great.
Sounds good.
okay.
Yeah, I think that would work.
I mean, why put to find a point on it? I mean, if they're individuals. Period. Thank you, Mayor.
You're welcome.
I'm just making a note here. Okay. Okay,
Did you have anything additional, Mr. Mr. McConville?
yeah, so the other issue, which I outlined briefly in the memo that I circulated, relates to recent litigation that was resolved in the city of Bedford. And just to refresh everyone's memories, the facts of that case were that a woman, on her landlord's advice, made calls to the police to complain about some ongoing issues with her neighbor. And the Bedford Police Department responded on several occasions to investigate the calls. And the city then sent a nuisance abatement letter to the landlord of the woman who had been contacting the police to complain about her neighbor. And the landlord, having received the letter from the city, then filed an eviction action against the
Complaint.
tenant. The unlawful detainer action was resolved in the tenant's favor, and the ACLU sued the city of Bedford. There's no opinion in the case because it was settled, but I have been able to look at a copy of the settlement agreement that I obtained from the ACLU, along with the complaint that was filed. And essentially, they were alleging that the ordinance in question would have well, they alleged that there was racial animus that was the genesis of enacting the ordinance, which was enacted back in 2005, and that it would have a disparate impact against people of color. They also alleged that it did not require convictions, only citations. They alleged that it had no provision in it that would exempt victims of domestic violence from its enforcement. And they brought claims under the Fair Housing Act, along with constitutional claims under, I believe, the Fifth Amendment and the 14th Amendment. The suit settled for $350,000, which is an alarming number. And the ACLU in press releases has since called on municipalities to repeal ordinances that are of this ilk. I think that, you know, our ordinance can be tweaked so that it's just facially different from the Bedford ordinance, and would be sort of positioned in a way to rebut a lot of the arguments that the ACLU was making. And I have a list of things I think we could do that would rebut any sort of facial challenge to the ordinance. And of course, another one of your alternatives as a body would just be to repeal that enforcement portion of the ordinance. And just to orient everyone, the portion of our rental registration ordinance that is at issue is 1280.10G, subsection G, that's titled Revocation of Rental Permit Notice to Show Cause. The way the ordinance currently reads, an owner of property can be, if there are two citations that are issued in connection with occurrences at the property that relate to essentially our public nuisance, our criminal public nuisance ordinances, and it's things like disorderly conduct, peace and noise disturbances, then upon giving notice to the owner of the home, the building commissioner asks them to show cause as to why their rental permit should not be revoked, and the building commissioner is given the authority under our ordinance to revoke the rental permit. And then that revocation can be appealed by the owner to the Board of Zoning Appeals. So I see the language as it's currently drafted being problematic because there are several aspects of it that are on point with the Bedford scenario. In particular, we are indicating citations instead of convictions. And then in addition, we are just going right to the owner of the property without involving the tenants in any way, in any sort of action or discussion. The components of an ordinance that I think would work constitutionally would be, number one, that we sort of change back to the standard of convictions as opposed to citations, so that it would be convictions that would trigger any sort of building department action. Number two, that we build in a protection for victims of domestic violence. Now we have that language in there. Third is, I think we could broaden that a little bit. And if you notice under G6, one of the conditions that the building commissioner or the BZA can consider is repeated complaints from adjacent residents that conditions exist which are detrimental to the peace, tranquility, and quality of the neighborhood. I think we can add an additional provision that asks the building commissioner and or the BZA to look at whether there was animus against a protected class in connection with any of those neighbor complaints. You know, is a neighbor complaining to the police about a home for reasons that really don't relate to peace and tranquility? They relate to a discriminatory reason. So we could include a sort of more broadly worded protection that would capture that kind of behavior. And then there are a couple of things that I think we can do that would improve the due process that's provided under the ordinance. One is, the way the ordinance is currently drafted, we give the building commissioner the right to revoke. I think that should be changed to give the building commissioner the right to refer the matter to the BZA, so that a hearing is conducted before a rental permit is revoked. I think that's a significant layer of due process that really addresses a lot of the concerns that the ACLU was raising in their complaint against the city of Bedford. And then the other thing would be to include an obligation on the part of the city to provide notice to the tenants as well, so that it's both the owner and the tenants who are getting notice of that BZA hearing. And I think that would create a set of circumstances where A, there's additional due process in place, and B, we're giving the tenants the opportunity to explain their side of whatever story is there. And then the final thing for your consideration would be, you know, we had formerly the ordinance had required 3 separate occasions to have this process of the building commissioner having the power to revoke. It was proposed that we reduce that to 2. You could go back to 3 again as an additional protection for the city of not getting to the point of, you know, a controversy that could cause an eviction that might spur a fair housing claim, or at least draw the attention as applied of the ACLU or anyone else. So those are my thoughts. I hope that was clear. I'm happy to go through that list again to the extent it wasn't clear, and would open it up to all of you for comment.
What's everyone thinking? I think what he's suggesting, all of those certainly provide those additional protections and leaves it less open to interpretation, or, you know, that it's something untoward, you know, that it's something that should happen, but you're doing it in a way that, you know, ticks all the boxes that you're doing it right.
I think, you know, if you look in particular at the set of facts in the Bedford settlement, the thing that I think really got the ACLU's attention was that the woman who was facing an eviction action was facing that action for conduct that she didn't even engage in. She was
Right.
the complainant.
She was complaining.
She wasn't the person creating the nuisance. She was simply utilizing city services and complaining about another individual.
Mhm.
And so the city's conduct, I mean, just to put everything in perspective, was, you know, pretty egregious. And it, you know, as you know, well, I shouldn't assume, you know, there are differing kinds of constitutional claims that can be brought under an ordinance such as this one. There's, you know, facial challenges to the language itself, which says, you know, the language as it's drafted is just unconstitutional. And then there are challenges of an ordinance as applied, meaning the way you applied the ordinance is unconstitutional. I think, you know, in Bedford's case, it was kind of both, but what really got the ACLU's attention, in my opinion, was the way the city applied this ordinance. They applied it to the citizen who was complaining about nuisance conduct of another party.
It's sort of weird.
And then going to the owner really as a way of stopping the complaints from occurring, and the owner reacted by evicting or filing an action to evict this woman. So I suspect that in University Heights, we're not going to have those kinds of as applied problems with our police department. You know, certainly we can strive not to have those as applied problems. I think we do every day, but I think the ordinance still needs to be buttoned up facially, and that's the reason for my recommendations.
Thoughts?
Just strike G and pass it, and then go back to work it and making a facially sound G.
You could do that.
I mean, I think there's just been so much work on the ordinance as a whole.
For
And I
years.
think that there's been a change in circumstance or change in law. And I think that we need to go to work on that. And I think that do you see any problem with passing this ordinance without a revocation provision?
I don't. And part of the reason for that, in all candor, is that There are cross references between this ordinance and I believe it's 648, chapter 648, and in particular 648:17 is our criminal nuisance ordinance. And we ought to be taking a close look at that. So I think we can maybe do that in tandem.
I thought 2 years ago, you made an amendment to the nuisance to add the language regarding domestic violence. I thought that was independently amended.
Yeah, we did. I just think that in light of the Bedford case, I'm kind of wanting to go back to 648:17 and make sure that I'm comfortable with it and everyone else
Sure.
is too.
And then a couple questions in comparison to the Bedford case to
Mhm.
compare us. The eviction action, was that at all a provision of the ordinance itself, or was that the target landlord's unilateral response to the rental permit revocation action that the city took?
So I believe that Bedford had a provision in their ordinance that indicated that if you, as an owner, received a citation like that and remediated the nuisance by eviction, you would not pay a fine.
Okay.
And so that was an additional problem.
So do you see any difference between that, which is, it seems to be less the regulation of commerce and more of going towards an individual's habitation, like a specific action of the individual. So it's prescribing an eviction action.
Yeah, I think as a practical matter, you know, if there aren't due process protections in place, and a city citation results in an eviction action, the city is at risk of seeing a lawsuit under the Fair Housing Act. That's my concern. Is even if you're not promoting, so to speak, or incentivizing the eviction, if as a practical matter, there is no due process provided and an eviction results, I think, you know, I think the tenant may still have a claim.
Okay, thank you. I guess then I would just say I'd be in favor. I think there's a lot of moving parts, not only here, but elsewhere in our ordinances. I'd be in favor of striking G and moving to send the ordinance to council.
I agree.
Okay.
John?
That works for me too.
Yeah.
Fine.
Mrs. Weiss?
When do you foresee this being completed? Like, I don't think it needs to come back to committee. I think it can go to council. We've been
Agree.
talking about this for a couple of years already.
Yeah. I think we've gotten it to a really great point, not without a lot of work by this committee and certainly previous committees, some council members that have worked hard on it for years that are no longer serving. I think it's in a really good place.
So, I mean, I can make these revisions that are being requested in, you know, so that you have it at your second meeting in November.
Okay.
Now there's one other change. I'm sort of kicking myself that we haven't talked about this before in all of our conversations under this ordinance. We do have a requirement under this ordinance that in order to obtain your rental registration permit, you undergo an inspection of the property. And I think, I know for a fact that the city of Bedford is also involved in another piece of litigation that hasn't been resolved that relates to a similar inspection requirement that doesn't contain language that's similar to what we put into our point of sale ordinance, where we say the owner can indicate that they don't want an inspection. And then that triggers you know, a course of action for the city where the city either decides to issue the rental permit without an inspection, or the city seeks to obtain the right to an inspection through an administrative search warrant. And I think we ought to mimic our point of sale ordinance language and just insert that right into our ordinance to avoid that.
I think it's a matter of public safety. I mean, the fire department, don't they usually inspect, Mayor?
Not necessarily. We do have an inspector who is dedicated primarily to the rental registration program.
Who's familiar with the things the fire department requires and.
Well, there's some potential for overlap there.
Okay.
The Fire Prevention Bureau could be doing these, but it has been done in the housing department. We have an inspector who's assigned to do rental registration as one of his duties.
Mhm.
And then during COVID times, we have adjusted how we handle them. The latest version of it is that we have him come out and do the exterior inspection, and then an interior is done remotely where he uses a phone with Google Duo
Okay.
looking at it, and a tenant or the landlord or someone in the house has Google Duo on their phone as well. And then they work together where they're aiming the phone at the smoke detectors, the carbon monoxide detectors, and other features to accomplish an interior inspection. Not quite the interior inspection we would have in pre-pandemic times, but an
Right.
interior inspection.
You have to be creative.
Right. And there were several different things that we tried with respect to that. And that's where we are now. Shaker's doing something similar with Google Duo and using it for those sorts of things, and also for re-inspections and so on. So that is something we're doing. The other thing that's perhaps an interesting feature here that's probably worth mentioning is that we conduct the rental inspection after the property is occupied. We don't do the rental inspection when the property is vacant. We wait until it is occupied and then do a rental inspection. That's what triggers the inspection when well, yes, because if you have a property that you intend to have be a rental, you could file a rental permit, but we're not going to want to inspect it until a tenant is actually already in there. And the reason for that, the leading reason, I would say, is to ensure that nothing is going on in the interior as the tenants are living in it that is hazardous to the tenants.
Okay.
That if you do an inspection when the property is vacant, a lot could change in the interim.
Mhm.
And this helps us monitor that. But Luke's point, we want to avoid a Fourth Amendment issue. We want to avoid where this is treated as an illegal search, and certainly I respect the Fourth Amendment as we all do. So wanting to do a modification that allows somebody to opt out, and then we can make a decision administratively whether we want to seek a warrant or whether we simply proceed and issue without doing the inspection. But obviously, if we have some reason to think that we ought to be in there, we're going to go the court route.
Right. Mrs. Weiss?
If we're going to add this in, then there's going to be people that don't want you coming in there. The renters aren't going to want you coming in. So why don't we just revert back to an empty house? So at least something could be done. I mean, why do you want to go through all of this hassle with having to get a warrant and all this other?
Brendan, I think you're muted. Did you have something?
I didn't want to interrupt, but I've been working with Dee and Ruth a lot in the past few weeks. And one point they brought up with this is with the 3 unrelated tenants, where some of our rentals have 4 or 5 bedrooms, 4 or 5 unrelated people move in, we inspect, and then we essentially have to ask the tenants or the landlords for 1 or 2 people to leave these homes. So, you know, I know this is a very contentious issue, and I don't want to say this is what we should do or what we shouldn't do. But the process as it stands, I think, can make the city look bad and
Definitely.
can make a lot of inefficiencies.
We also added when somebody signs up for a rental permit that they have to put the names and phone numbers down also. So if we follow up properly, I don't want to have to get into I don't know how many people won't let you in, but that's first of all. We don't know how many people are going to do that, but to start getting involved in all of these legalities, if somebody's not going to let you in, I don't know if that's the best use of our time.
It hasn't really come up on the point of sale side, though. I mean, you know, it's one of those things where, and maybe it would be different here because, you know, with the point of sale, if somebody didn't want to submit to the inspection, we could say, okay, we will go get an administrative permit in the, you know, an administrative warrant. In the meantime, this is tying up your ability to sell your home because we're going to have to go to court now and make a case, and then we're going to have to, you know, get the warrant and you know, schedule a hearing to get it, wait to actually get it, and then schedule a time where we go out there and execute the warrant, which, if you are pressed for time, is going to slow down that process. And
These
usually
people won't
are
be pressed for time. They're in there
you
already.
know, right. And, you know, it also begs the question, do we want it to be our inspector's job to go into these apartments and count the beds? Because that happens. And, you know, personally, I wouldn't mind seeing that go away. You know, it's intrusive. And, you know, part of that's also goes back philosophically into 3 unrelated versus what is a safe number of people to be in this home that doesn't overburden the home or the neighborhood.
Yeah, I mean, I'm just going to reiterate, I thought that's why we updated our rental permit form to avoid that. And then, but we do have to check up. I mean, you have to make those phone calls every year and make sure that those same people are living there. That's all.
Mm-hmm. Right. But, you know, the question though is if you leave somebody off the form and you can't call somebody you don't know to call, but you show up at a house where there's supposedly 3 people living, but there's 6 beds.
Right. But again, if somebody is avoiding the law like that, right?
Right.
They're not letting you in anyways, then you're going to have to get the warrant. You're going to have to go through. I don't know. I just feel like we don't have enough resources to be able to follow through on all of that. And I don't know. That's just my feeling.
Well, I think maybe one of the things we should consider is, I mean, the resource issue is definitely important, but if there's a compelling interest for the city to do this, then we can figure out the resource issue. I'm not convinced that we necessarily have to do a rental inspection after the home is occupied. I mean, I want to be sure that there's smoke detectors. I want to be sure that there isn't something there that's going to harm people.
Right.
I'm more concerned about smoke detectors and carbon monoxide detectors than how many beds are here and who might be sleeping here besides the 3 people that are listed on the application.
I'll give you that, but
Mhm.
I think this is the primary way that we keep a lid on animal houses. I mean, if there are only supposed to be 3 college kids in the house, but there are in fact 6, I mean, how do you prevent that? I mean, you have to go in when they're in there and count the beds.
Wow.
I don't see any other way of doing that. And it's a problem in this city where we have tons of kids living in these houses. It's disruptive to the neighbors, and it's a depreciating value of homes.
Well, and that's the other side of it. You're right, Phil.
John or Justin, do you want to weigh in?
I appreciate the mayor's comments around protection of renters. I think that's my primary concern as well. Although I understand the need to keep people from living in houses that are overstuffed.
Yeah.
Which I think, to be frank, if there is an issue like that, I believe it will become apparent to us in more ways than just a rental inspection. I think that if there's a problem with an animal house next door versus, a couple kids who don't have enough money and decide to have too many people inside of a home, that it will become apparent who is living next door by the other things that we've discussed, and hopefully we can take care of it that way.
Cars and trash and
Right.
volume of each.
But in once that, I mean, I love using Bedford as our poor weather vane, but once that's resolved, if we can kind of take a look, is there a constitutionally sound version of this, or do you think we should remove it as well until we can better understand the implications of the Bedford suit?
When you say remove, do you mean remove rental inspections? Or do you mean remove interiors? Or which part would you be taking out?
Well, that's my question, is I don't know what's at issue in the Bedford case. What about this appears in your review to be constitutionally unsound?
Oh, well, that you would simply mandate rental registration inspection in order to, that you would simply mandate an inspection in order to obtain a permit without having any sort of option on the part of the owner or the tenant to object. That is violative of the Fourth Amendment, and there's been recent case law that telegraphs that to us. So I think we need to build something into our, there really are a few different issues here. I think we need to build something into our ordinance that indicates to owners and or tenants that they have a right to refuse entry for inspection. And that refusal then triggers
Another process.
a choice that has to be made by the city, either to issue the permit or to walk through an administrative warrant process. And if you obtain the warrant, you conduct the inspection, and if you don't obtain the warrant, you issue the permit. So that's one issue. The other issue, I think, is the timing of the inspection. Do you want to perform the inspection on a pre-occupancy basis or post-occupancy? And then the third issue is really kind of a question along with an issue, which is, what do we do for renewals? Because we have bumped our registration requirement from a biannual requirement now to an annual requirement. And that, combined with inspections, will start to grate on people, I'm sure. So there will be an increase in, people refusing inspections if they're having to do it every year, especially if they have long-term tenancies. So, I mean, I don't know what we do on renewal. Do we inspect on renewal too?
Mayor?
Can you renew your permit every year, but have annual inspections?
You could.
Going back to your first point, I just feel like if you're telling us that there's case law, why are we even considering going into their house after there's a renter in there already?
Well, there is a legitimate governmental interest in inspecting the interior of rental properties. Number one, you want to make sure they're safe.
But we could do it beforehand.
Well,
You're talking about that there's case law when there's people in the house, renters.
But it's also the owner.
Oh, okay.
Either, and most municipalities have the experience with owners where they say they're used to the drill, if you will. So they say, go ahead, inspect, I want my permit.
Okay, yeah, no, I was thinking more of the renter, so that's a different story then.
Yeah. Well, and certainly I would think that the landlord would want a safe property for those people to go into.
There are lots of landlords who cut corners.
Okay.
I mean, that's not to say that they want an unsafe property, but that also means to say that, you know, if there are minimum requirements, they will follow the minimum requirements.
Brent,
Well,
did
and
you have a
and
thought? I'm sorry, go ahead, Luke.
I was just going to say, I think, you know, I'm willing to be a little more blunt with that. I don't think this is necessarily the norm in University Heights, but we do know that there are landlords out there who are perfectly happy to invest no capital whatsoever into their home and let it deteriorate over time and rent to people in slum conditions. And there is a clear governmental interest in preventing that from happening
Sure.
and making sure that the housing is habitable and up to code, because the codes are designed, you know, for safety.
Just to clarify a point on that then, again, going back to the issue of the slum kind of conditions, the privacy interest vests in the occupant of the apartment at the time they take occupancy of the apartment.
Or
So
house.
or house. So I would imagine that if I'm a tenant and I know that there's a rental inspection, and if we do a good job of educating, you know, tenants that are there, that you can call the city and we will come out for an inspection of your property to find that your, you know, XYZ isn't working, your windows don't open, your back door is locked permanently, there's no, you know, railing upstairs. That we might be invited in by them at a later time. Is that right?
Yeah, that's certainly a possibility. The Fourth Amendment protection extends to either the owner or the tenant.
And we have had
But
cases exactly like that.
yeah,
Yes, where the tenant has sought us out and said, we've got a situation and we would like the inspector to come out and see if this is something that should be written up. And yeah.
yeah, that situation can kind of go either way. You can have, on the one hand, you can have the tenants who say, we don't want you to come in because if you're going to come in, you're going to discover that there's 4 unrelated people here, or that we're growing marijuana in the basement or whatever. And then you can have the tenant who says, I want you to come in because I've complained to my landlord 5 times to fix
XYZ.
the leaking ceiling and they won't do it. And so come on in and inspect.
Mhm.
So that the way the tenants react can go either way. And the same is true of the owners. I mean, you can have the owner who just wants expediency. They don't mind, you know, regular, you know, inspections at regular intervals because their property is kept up, and they'll, you know, invest a little bit here and there when they need to, versus, you know, the more slumlord type owner who would just rather cut corners and not invest anything if he or she doesn't have to.
Yeah, the one thing I would point out about if we were to say inspections occur when the property is unoccupied, it should be noted that there are often times with these rentals that there's no significant period of them not being occupied. That
But
sometimes,
if there are people who rent for 12 years.
right. But also you have the people that rent for 12 years and you don't want to not go in once in 12 years.
Right.
But, so you've got the people that where the rental term ends on the 30th and the new term begins on the 1st with new people, and people are moving out on the 30th, moving out on the 1st, and we can't have an inspector everywhere on the afternoon of the 30th inspecting every house. That it just wouldn't work. So we would run into that problem, and we wouldn't want to say, no, you can't let your new tenant move in because we haven't inspected yet, but we can't get out there for 3 weeks because we're backed up. So I think you probably leave the ability to inspect when it's occupied, but maybe we relax the idea that it has to be occupied before you inspect. And that in the case of a long-term tenant, you know, when you have a renewal and you're up for inspection, you still do an inspection, though it's occupied, but it's really for the tenant's benefit. And the long-term tenant, You know, sometimes landlords let things slip over time, and sometimes tenants don't realize what their rights are.
Mhm.
So it's for their benefit.
So Luke, were you initially saying that there was language that exists in another ordinance of ours that we could mirror?
Yeah, we drafted language in our point of sale ordinance that makes it clear that the owner of property can refuse a point of sale inspection, and then it causes the city to go through this choice, this tree choice
Mhm.
that I described. So we can essentially mirror that language and. you
And
know,
that puts us
create-
on solid footing as far as somebody
Yeah.
challenging it.
Yeah.
How does
Yeah,
everybody
and
feel
then- and
about
then I
that?
think in practice, you know, you can leave the choice up to the owner as to when they want the inspection to occur. Um,
Well, the owner or the occupant, or owner and or occupant.
Well, I would say owner, right? I mean,
It's their property. They have to, they
they're
would
the
have to
ones-
arrange it, schedule it with their tenant. The onus falls on them to do that.
Well, sure, I'm not trying to shift the burden onto the tenant. I'm just saying that when it comes to the consent,
if a tenant's already in there, you need everyone's consent.
right.
Yeah.
Mhm.
That's what
But I think you could give the owner the choice.
Did we
That's
answer
fine.
your, did we answer your 3 points, or is there one that's still outstanding?
I think you did. I'm still though a little bit unclear as to what our policy is on renewals. Do we inspect every year? Is that what we're intending to do? I think the way the ordinance is written, that's what it contemplates.
I
Is-
think
I
every
haven't
other
thought of-
year, I think every other year is fine, since they have to reapply every year. I think every other year inspection is okay.
Thoughts?
Yeah, I think the critical thing is getting fresh information every time there's a change in tenants, which means
Correct.
every year.
Mhm.
And even if it's just to get a confirmation that's the same people, that's important information for the city to have,
Mhm.
especially when there's a problem. But I think we can get by with an every other year inspection. I think that satisfies the interests of the city generally, and also doesn't double the workload of the department.
So you would have annual registration, biannual inspection.
Correct.
Mhm.
John, Justin? Good? Yes? No? John, you're muted.
No further comment.
No further comment. Brenda, did you have a thought?
Yeah, the city does inspect on a code basis. So the code doesn't change if there's a tenant or not a tenant. You still need a GFCI outlet by the sink if there's a tenant or not.
Yeah.
So
Right.
I don't know if inspecting before or after the tenant moves in actually changes the process, except for looking for the 3 unrelated people in the home. That would be the only thing I see that would possibly be more difficult to check for.
Yeah, and speaking to Phil's point, I mean, Phil, I live on Loyola, so I'm like in the heart of the matter. There are students who live on Loyola each year, and you kind of know when you have a group of partiers right away. I mean, it's not ambiguous. They either are or they aren't.
Last year we had them, this year not so much.
And I know the city has had some success in the past, including during my tenure, of when there's a problem house, establishing that there's a violation, either through the observation of building officials that then creates a citation to the BZA, or through probable cause that causes the municipal court to agree that an administrative search warrant should be issued to determine how many people are living there. I've spoken personally with KJ Montgomery about this issue. She's very supportive of the idea of the city coming forward with a problem home saying, we have reason to believe that there are more than 3 unrelated. There's all these problems. We would like an administrative warrant. And she's basically said, I'll listen, very attentively to those arguments and want to support the city and its desire to maintain peaceful, tranquil neighborhoods. I mean, I do think we still have a lot of avenues at our disposal if we have a problem home. And that, people who are neighbors should be encouraged to, reach out to city officials to let us know when there's a problem. I know that we do that on our street. I mean, luckily, most of the time we've had tenants that, yes, they're in and out at 1 a.m, closing their car doors, but they're not partying with 200 people in the front yard
Right.
At 1 a.m. And there's a big difference. So.
Yeah, it's, the partiers are definitely a problem, but, even a casual, passive group of renters, if there's 5, 6 girls in a house, nice kids, they're quiet, but they're gonna be 5 or 6 cars
Right.
of the boys that are gonna be there. You're gonna have 10 or 12 cars in the driveway. And that means there's no trash being picked up continually, and the house is really getting used and depreciating. So, they're a problem any way you look at them. So when you say there are means by which the residents can address these issues, do they really work? I mean, what do you? So I've got one next door to me. I call the city hall and I say there's half a dozen people living in this house next to me. What do you do for me? Then what happens? The city's got to come out and do an inspection, or what happens?
Well, that's going to be up to the administration, but I know in the past, in those circumstances, the city has sent a building official out to the street, had him sit there on several days in a row and observe how many cars were there. And then based on what they observed, issued a citation that said you're in violation. We have the evidence, and let's go to the Board of Zoning Appeals and talk about it. And
Let me stop you right there. That's been a problem for years. They sit out there during the day, and these kids are at school or they work. They're not there during the day. You need to catch them. You need to come by on the weekends, and our folks don't work on the weekends.
Oh, maybe we should start having some swing shift inspectors for those reasons. Maybe we make it part of the job description that from time to time you're going to flex your time and work one night, but take a morning off.
I mean, especially if you get a complaint.
Yes.
Yeah, well, I think if there's a complaint, then I think there's an onus on the city to go out and figure out what the facts are.
Right.
Are there 3 people living there, or are there 6?
And similar to that, I mean, we had a complaint not too long ago about light pollution. That one neighbor had put in lighting that was causing light to shine into the kitchen of another neighbor in a disturbing, undesirable way. Well, we arranged for our inspector to come out at night and observe lights. Because the only time you're going to know what the lighting is like at night is at night when the lights happen to be on. And but we did it. We arranged to flex that particular inspector's time, took a morning off, and came in, in the evening and observed the lights and saw what the problem was.
Okay.
So it's doable. It's just a matter of being proactive about it.
Right. So Luke, so it's already, I'm looking, it's 8:21. We have
I can make
another
these
couple of items.
changes. I can make these changes and have this ordinance for you for your second meeting in November.
Okay, great.
Mhm.
Sounds good. I think it's in a good place. A lot of hard work, a lot of people, a lot of years.
I
All
would
right,
agree.
good. So we'll look for that then.
I feel like we're making substantial headway here.
Mhm.
Yeah. So thank you. Thank you, Barbara. And thank you, Luke. And thanks
Thank
everyone.
you. Absolutely.
Yeah.
Mhm.
Review of building department fees. I know that the mayor had forwarded the list of what was suggested to everyone on September 1st. Did anybody have any objections or thoughts, or can that go forward as well? There didn't seem to be anything that seemed unusual or out of line with the other communities.
Works
Are
for
we
me.
good? Brandon, yes?
One thing is that the contractor registrations for next year have already gone out. So the only thing is I don't know if it would be fair to change that halfway through 2021 and have, if you register in March, then you pay more.
Right,
So that's
we've
one
got,
thing we
we've
can
got
figure
8
out.
weeks left. Do we want to have this begin January 1st?
That's what I was asking. Yeah, I wanted to bring that up because we've already sent registrations out for
Mhm.
next year.
Yeah.
For next year.
I don't think that's fair.
Okay,
My only comment is, since we were discussing, oh my goodness, over the last couple of years, that the fee itself has to not exceed really the cost to have the program of the rental registration and inspection program, and fees and the costs associated with the entire department. These fees that you're proposing, does that equate to running the department for the rental? Okay.
Yeah, I'm glad you brought that up. Yes, the fee increases are to cover the cost of providing the services. It's not, this is
not
not.
a moneymaker.
Right. It's not in any way supposed to be a tax. It's not in any way for the city to make money on people. This is to cover the cost of actually providing this valuable service. And it makes more sense that the people that are asking for these services pay for it through a fee than to have other taxpayers subsidize it for them.
Right. Okay. Good.
Right. Yeah. So as for the contractors, if the applications are out, I suppose there's a workaround there. If we've already quoted a fee for next year for the people that got the applications, it may be that people who registered per that fee, per that application, pay the fee that we've quoted them, and then after a certain date, it's a different fee. So somebody comes to the city later next year, wasn't a registered contractor, wants to register now, well, there's a new fee.
Yeah.
Mhm.
So we'll expect then to put this on for the first meeting in January, or do we want to do it in December, or even now to have it just take effect January 1st?
It should really be up and pass before the end of November. So in 30 days.
Okay.
Yeah, I mean, I
All
suppose
right.
you can pass it on emergency in December and have it take effect January.
But there's no reason it couldn't go on the second meeting in November, right?
No.
Or first meeting in,
yeah.
First is a little close, or well, we don't need to make any changes to it, Luke.
It might even be on the agenda for a first reading on Monday.
Okay,
So I asked Kelly to put it on 2 weeks ago, but obviously, we know what
right,
happened.
right.
Well, I thought there was one that was read and one that wasn't. I thought the contractor registration.
Yeah, we're talking about the
was-
building department permit fees here.
Oh, okay, yeah, no problem. with
Right, the
that. contractor
one is up for a second reading next time potentially, although I don't know, I think because it's in committee, we didn't put it on.
Right.
But yeah, we should go ahead and have the first reading at the next meeting.
Okay,
And if it's all in order, then we can have it at the second meeting of November.
fantastic.
On
Okay,
second reading and vote on it if we're all set. I guess the only thing is with the contractor registration fee, we need to work out how we want to handle the we'll want to change it so that the fee is effective the first of the year for the folks that are renewing per the renewal fee they got. They can pay the old rate.
Yeah.
So I guess we need to say so somehow. Luke, how would we, Luke, would you be able to craft some language that says something to the effect that people registering for the new year prior to December 31st qualify for the new rate? Brendan, do you know what was on the form? If it
The
gave
forms that were sent out had a quote of $100 for new registration, which
And a
we sent
deadline?
to every contractor that's registered, I believe, in the last 3 years.
Sure. And
That's how our programs worked.
what is the deadline on that?
There is no deadline. They register as they apply. So if we want to do it where if you have this letter with the quote of $100, that's your fee. If you don't,
We'll
you
honor
pay
it.
whatever the increased fee.
I think
Yes.
it should go by the date. I think establishing a date by which it's effective is less arbitrary. And you can do that by either establishing a date in the ordinance itself as to when it's going to be effective, or you can do it by simply allowing it to go into effect per, the normal rules. So immediately if it's passed on emergency, or 30 days if it's not,
Mhm.
following passage. And then,
What would you recommend? One or the other?
well,
Does one have more merit?
I think January 1st is fine. I think, if there's a custom that someone can speak to, such as, well, we send these out in November, we get them back usually by, the end of February. You could, move the date to March 1st. It really just depends on what you're trying to achieve.
From what I hear Brendan saying, and correct me if I'm wrong, you're saying that people do this like sort of a rolling basis. So it's not as though you sent these out and they're all going to be back by December 31st.
Correct. We don't put a due date on them because not every contractor does
Right.
work in the city. the
They're not
next
going to
year.
need, right. So I would say January 1st. What do you think?
I think that's fair.
Okay.
I just worry that administratively that may be a headache because we sent out a letter saying $100. People are going to then send in a $100 check, and then we'll have to call every single one back and say, actually, it's this number instead. Can you send a new check?
The other thing we could do is send a follow-up letter to the same list explaining that the fee is going up January 1st if you want to take advantage of the old fee registry.
Perfect. I like it.
And I know that means running off another letter and mailing it, but then
Sorry,
I
Brendan.
think that
Yeah,
button,
no.
Great.
Whatever's decided, I'm happy to go with.
How many contractors is that?
I don't have a number, but it was a substantial stack that Dee and Ruth printed and Rachel has gotten out.
More or
I
less
could
than 100?
look at our system, give you
Rachel
an
helped
exact
stuff
number.
all the envelopes. So, yeah.
Was
I
it-
didn't
was
realize
it-
what the letter was, though, that she was working on. Okay.
Are you talking about 100, 500, 1,000, or 10,000?
I would guess somewhere in the 500 range.
Okay.
Yeah, the other thing that Rachel had said was the next time we do a letter like that to all the contractors, we should use Porath and get a discount on the postage and the printing using their bulk permit.
Yeah.
So we could probably do that,
Okay.
the follow-up letter.
Are we agreed?
Can we email those things?
We don't have emails for everybody.
Maybe we should ask for that on this new letter, and then you can get
Yeah, right.
DocuSign
Yeah.
and they could
There you go.
sign it automatically and email it
Yeah.
back.
Well,
DocuSign.
I will say that when we get simple Citizen Serve implemented, we're gonna have all these contractors registering with online accounts with Citizen Serve. And when we move that direction, that's gonna take care of that.
Okay, so apologies to everybody that'll have to facilitate this follow-up, but moving forward, you won't have to try and make it more palatable, sorry.
Okay.
Okay, last item and quickly, and we can always have another meeting to discuss this further, but I know that Mrs. Weiss had been approached by a resident a while back now with a question related to the ordinance section 1280.11A9. And Luke, you had recently sent us a memo talking about that. And I would like for Mrs. Weiss to be able to have that information and a brief discussion so she can answer the question that was raised.
Yeah, so I had provided information about the Hudson ordinance, which essentially in certain areas of the city allows for secondary structures that function as residences, what they call accessory dwelling units, as long
Mhm.
as all of the other zoning requirements are met. Then they had a second category. I'm just trying to refresh my memory here. Yep, for guest houses. So the one type of dwelling included, like kitchen facilities and bathrooms. I think the guest houses or guest rooms would be more in the nature of a carriage house, which wouldn't have that, those facilities. And they have far more residential districts than we do in Hudson. So it's not a permitted use in all of their residential areas. It's a permitted use in some of them. And that's
Probably less in our case because our lots are so small when you talk about the zoning restrictions.
But I think as a practical matter, you'd have, in certain areas of the city, you would not be able to meet our zoning ordinances and have an accessory unit, for, whether it's setbacks or land coverage, those ordinances would be implicated almost certainly. On larger lots in the city, you might be able to have a small accessory dwelling unit. And so then the question would be, do you want to allow for that use?
Right. I mean, I just, I wanted to pose the question because a resident approached me. We have some very small lots in the city, but then, we have other medium and large size lots. So, I didn't know if we wanted to even think about this at all. If we don't, that's fine. If we do, I think it behooves us to, see what kind of variance, what kind of lot size we would allow it in.
Were these temporary structures or permanent?
No, they're permanent.
Permanent. Okay.
I guess you have multi-generational families now, and many don't have first floor bathrooms in University Heights, and this is actually cheaper than adding on to your house.
Mhm. Anyone?
Are there examples of what these conceptually would look like? Would they be subject to ARB then? Like you would have something that matches the main structure?
You could. There's all different types. I looked online when I was looking at that Hudson.
I was joking at Michelle for the different designs that are available, but it actually, some of them are quite charming. They look like little English countryside homes for your, what was the other name? They were
Tiny
nanny
Homes.
nanny homes. There we go.
Granny pods.
Granny homes. There we go.
Pods.
Granny pods.
Granny
pods or granny
that
pods?
was it. It was pods.
They have their own water. They have to be hooked up to water and electric. I mean, they're completely their own home. They're just behind the existing house.
Something for further discussion at another meeting.
Yeah, I mean, this isn't formally on the agenda, so we should
Right.
probably, I mean, I don't mind.
Oh, it is on this agenda.
It is on the agenda?
Mhm.
John,
Yeah.
what do you think as an architect? I mean, I know it's not necessarily aesthetically pleasing, but I mean,
Not on the agenda.
I didn't see it on the agenda, actually. That's why I was confused where this was
Yeah,
coming.
Yeah.
review of ordinance section 1280.11A9, home occupation
Oh,
regulated. It's the same
okay.
one we've had a couple of times and we've just never gotten to it.
All right, I didn't realize that's what that was. Okay.
Yeah.
Mrs. Weiss, did you send examples? Everyone's talking about these examples. I didn't
No,
see.
I just looked online.
Oh,
If you type in ADU, they'll give you lots of different.
what am I typing in?
ADU.
ADUs, one word?
Well,
It's
for
it's
accessory
an
dwelling.
abbreviation. Accessible dwelling unit.
Here we go.
You're an architect. How do you not know this?
I don't do accessible dwelling units. These are like the pop-up houses, right?
You do bigger things. Not tiny
I
things.
would go broke if I was just doing this.
Baxter would be eating budget kibble.
So these are like these pop-up units then. Where would these go? Like in the back of the house?
Yeah.
And you usually have like a sidewalk that goes to the main house.
So there would definitely be multiple variances involved. I mean, do we have, I think we do, about how much green space you have to have on each property? I know Beechwood did when I lived there.
Yeah, no, I mean, there's the biggest variance is the lot size. I mean,
A lot of size. I mean, they're cool, but you know, what are people gonna, they're not gonna put them on Airbnb, or what are they gonna
No,
do?
no, I think it's
No.
what Michelle was saying with multi-generational families where you have elderly parents that cannot remain in their homes, that kind of thing.
but still
So
want to
they
have
come-
independent living.
Yeah,
Right.
the one other feature of the Hudson ordinance is that it indicates that these units cannot be rented.
Yeah, it's a extended family kind of thing. Something to
Oh.
mull over and,
Yeah, I mean, I imagine would also not just not rented, but also not partitioned and sold.
right.
Right.
So Luke, I mean, basically Michelle has her basic answer to give to the resident that raised the question.
Barbara,
Yes.
could you repeat that? At least on my connection, you dropped out. I don't know if
Okay.
everybody else- could you
I
repeat?
was saying that Mrs. Weiss basically has the answer to the question for that resident, that there would be a lot of variances involved and you'd have to go before BZA and, yes, Luke, what's the answer she can give them?
Let me ask you this question. Let's say somebody, I'm not talking about a small lot. Let's say somebody actually has enough.
Like the people that have the big double lots or more than a double lot.
I mean, there's a bunch of streets that have pretty decent size.
We're not
lots.
talking about my house that has a lot like this.
Can they just
I would
go
think
to
it's his
BZA?
backyard.
Can they just go to BZA and planning now, or does there need to be a specific variance
Question.
for the specific ordinance for this?
I suppose they could go now because, I mean, so let me back up. I'm not sure whether there's any sort of special use permit or designation of this kind of use in our code, although I'm pretty sure we have some provisions about no more than one outbuilding.
There's
but-
there's provision for no more than one structure that you live in. Yeah, you can't have more than one living structure presently. That was a problem that came up on the Churchill. There was the effort to combine the Churchill and two Groveland homes.
Oh, that's right.
And Joe Chooney brought it up that it's in our zoning that you can't have more than one living structure on the same parcel. So we would likely run into that. There may be a way to do it through the BZA if it were amenable,
Yeah,
but what I was,
right.
if I may suggest, Luke and council, that if we want to telegraph to the BZA that we're open to it, then an ordinance that provides a roadmap for it gives the BZA something to look at. And that probably does it more than having an applicant come up with something that the BZA looks at and says, wow, this is way out there, and then rejects it.
Right. So the technical answer to the question, Michelle, is yes, someone could go to the BZA today. They would be, in all likelihood, they would at least be asking for a use variance, meaning I'm asking you to let me use my property for purposes that are not permitted. And then depending on the size of the structure and the size of their lot, they may also be asking for various kinds of area variances like setbacks and land coverage and that kind of thing. And the thing about a use variance, and I have tried over the years to make board members aware of this, is that the legal standard, and our zoning code needs to better articulate this so that it's clear to them. But under Ohio law, a use variance is only supposed to be granted under circumstances where the land, but for the use variance, cannot be used for the purposes for which it's zoned. And in this kind of scenario, you wouldn't be able to meet that purpose because there's already a residence in a residential district, so you can't meet that standard. So the board should deny an application coming before it if they correctly apply the legal standard. So as a practical matter, you know, folks should be saying, you're allowed to apply the BZA for a use variance. You're probably not going to get it unless they make a mistake. So that's just in all candor.
That apply also to second lot properties, Luke?
I'm sorry, I didn't catch what you said.
Does that apply the same to second lot properties? So like where it may be zoned for residential but can't actually be used to build a home? Like the second lot is too small to meet our current guidelines for building?
Yeah.
Although BZA has relaxed the size of a single lot where it's too small by current standards. I think that happened up on Raymont or Tullamore when we had the Knez house. I think Tullamore. Because the original structure that was torn down about 4 years ago was on a lot that's technically too small, but it had been built before the current zoning code was in place. And then obviously it can fit a house, and it had a house. But because the lot was smaller than what we would currently have, that was something, as I recall, BZA had to address and permit it. Or am I just making that up, Luke? I think that happened.
I mean, it sounds plausible.
I think it happened, but you know what? It may be. If you're not recalling it, it's probably because it wasn't controversial.
It's something that could be taken up in our new zoning code, hopefully next year.
Could be.
Oh,
And
yeah.
I tend to think of this in kind of in two ways. One is you would want to create a zoning ordinance with regulations. But the second is, I think before you did that, you'd want to study issues dimensionally to try to have an idea of what a minimum lot size would be before this would be.
Exactly. And I don't think there should be a variance. It just should be a minimum lot size with no, I don't know if you can do that, but with no variances allowed.
Well, Luke, if we set up something that just says if you have these conditions, you may do it, then they don't have to go to before BZA. It's just a matter of
You can or you can't.
You're right. If they can, then they can go to the building commission with their plan, not the building commission, the building department with their
Right.
plan, and file their plan and request their building permit. And then if there's anything along the way, A or B, et cetera, then that comes up then.
All right, well, Luke and Brendan make a mental note that when we get to that point with looking at those ordinances and updating them, that this is something that should be explored and updated as well. Created. All right. We think we've exhausted everything. A lot of good work.
Yeah.
All right, so we will look to see the fees for the uncertified assessment search request and the rental registration piece and the building department permit fees all on either the first or second agenda. As Luke, you've made notes to where you'll have it
Yep.
to us.
Yep.
I believe Mrs. Weiss has her question for the person who posted about the pods. And then the review of mortgage rental and utility system programs. We're going to wait and see where we land, how things shake out.
Yeah.
All right, good.
Thank you.
All right.
More time than I expected us to take, but I think an awful lot of really good use of the time. So I appreciate everybody being here.
Yeah, good job getting through it, Barbara. We were here a little bit longer than usual, but we covered everything. We did it thoroughly, and thank you for getting it done.
All right. Thank you, everybody. Have a great night. See you Monday.
Bye.
All right.
Good night, everyone.
Good night.
Good night.